Stowski. I'm State Representative for Suffield, East Granby, and Windsor. I'd like to welcome you this evening to this discussion on juvenile crime that's been taking place throughout the state in the past year or two. My colleagues and I are very concerned about the escalation of what started really as car burglaries and then now turned into violent crimes, including carjackings and use of weapons. We've all heard from our constituents on this issue. Most memorably, I've heard from a couple of them, one of them whose car was burglarized from in their garage while their little kids were playing out in the front yard. And another one, a working mom, who started up her car in the winter to try to warm it up outside her apartment, and they stole it while it was warming up. I mean, this is just a couple of small examples of what we've heard. A lot of it's a lot worse than that. I mean, we've had auto thefts now that have led to car accidents and to deaths. These are not victimless crimes. That doesn't mean we simply want to throw these juveniles into jail and throw away the key. Many of them come from troubled backgrounds, and they get mixed up with the wrong crowds. We want to try to at least get them on the right path, but we need to get some balance. We need to look at victims' issues as well as dealing with some of the issues with the juveniles that are acting out. There are programs that are used for first offenders. There's a lot of other things, a lot of other resources that you can deal with, but there's really no excuse for releasing somebody who's already been arrested 10 or 15 times. That's what we're really trying to get at tonight. This clearly isn't working, and we want to try to discuss some new ideas and discuss some possible solutions that we can talk about in the next legislative session, which starts in February. I want to introduce some of my colleagues that are here tonight. I'm going to ask them to say a few words before we go into the main program. To my left and your right is Carol Hall. She represents Enfield and East Windsor. Beyond her is Mark Anderson. Let me see if I get these right. Granby, Heartland, New Hartford, and Mark Anderson? Yeah. Okay. And then to the far right is Senator John Kissel. If you're from Suffield, he's your senator as well. He has, let's see how we can do this. Suffield, Enfield, East Granby, Windsor Locks, Summers, Windsor, and Granby. Is that it? Okay, sounds good. So anyway, I'm going to hand it over to Carol to say a few words, or Mark to say a few words, and then we'll get onto the main program.
Thank you. First, I want to thank Representative Fishbein to come to our area to present this. He is the ranking member on Judiciary and very much an expert, so again, I'm very grateful. And for Suffield Middle School for hosting, and Bill and Sue Regan of Connecticut Valley Views for recording this to make it available to those who can't be here, but especially thank the concerned citizens who came out tonight. When I ran for office, and I'm a freshman, one of my three major themes was make Connecticut safer. Yet the naysayers said, what are you talking about? We don't lock our doors. There's no crime problem in this district. But I saw the handwriting on the walls, the changes that were happening in policing, in the courts, in corrections, in criminal justice, things that were called reforms. But these reforms are well-meaning, but they've gone too far. And the victims seem to be forgotten. Now I know Representative Fishbein is going to drill down in the crime statistics, but just give you an example. A few years ago, I stumbled on a Hartford Current article that said one of my towns, the most rural, Heartland, had the lowest crime rate in the entire state. There were 2 reported crimes. One I think is a lawnmower was stolen in the backyard, and the other was a car was broken into. Now I follow the Four-Town social media very closely, and I don't think I'm exaggerating to say the little town of Heartland has at least 2 crimes a week. So you do the math on that. Crime is clearly escalating. It'll be a while before we have firm statistics for 2021. We're focusing tonight on juvenile crime, but just in my little town of Granby, a lot of people didn't hear that a woman took $200 out of the ATM and 3 guys drove up in a red Nissan, took it from her, and went speeding down the road towards East Granby. And that same vehicle was seen all over the state that day doing crimes, supporting crimes. We know that in Manchester, a 14-year-old raped and killed a 13-year-old, and the most he can get is 2.5 years probation. And in Hamden, we had a 14-year-old who, a few weeks after his ankle bracelet was taken out, he was out at 1:30 in the morning, shot and killed. So some critics say that our side of the aisle just wants to lock them up and have harsher penalties, but I think you're going to hear much more nuanced solutions tonight from Representative Fishbein. Then these same folks who say that we just want to simply lock them up say we need to simply lock our cars. So it's really blaming the victim. But we don't just care about our districts, which are somewhat suburban. We know crime is escalating in our cities, and we care about the safety of those neighborhoods also. My colleagues have all signed a request for a special session to address that, and I hope you'll support that. Thank you.
Carol?
Good evening, everybody. My name is Carol Hall. I represent the 59th, like my good colleague has already told you. For some of you that are here tonight, I know you usually are very familiar with your local representatives and senators. Just a little background kind of hits on some of the items I wanted to touch on tonight. My husband was a police, he ran the gamut in Enfield. He ended his career as a police chief in Enfield for 35 years. So over the course of those years, he raised through the ranks, a lot of it dealing with undercover work, detective work. And as the legislators made these changes to our juvenile laws, and really the major change came back in 2008, when we raised our juvenile age to 18. And if you look across the country, most of the states, I think almost all the states, is 18 now, which was an important change in the system, and it was a correct change. However, when that change got made, the structure of the system didn't change with it. So our good intentions, raising the age to 18, we've actually talked about raising it to 21, which I'm not sure I'm 100% behind that number yet. But raising it to 18, the legislators did not put the structure in place to support that raise in mechanism, meaning that you're adding 2 more years to the juvenile system with no support systems. So no probation systems, no backup systems for detention centers, no support systems socially for this increase in age. So as you move through the years, you've made all these changes to your your children's system without the support mechanisms in place to support those additional changes. So we're starting to see some of the consequences to those changes, where very minor arrests were totally dismissed. And as the years progressed and the system could not accommodate these additional children that were added to our system, more and more serious crimes were dismissed. So I think as you look at the progression through the changes that the legislators have made over the years, there were changes that were probably very well intended. I know they were well intended, but the system to support those changes just wasn't there. And the consequences is what we're dealing with today. So I know we have some great suggestions on how to make to make these changes work and how to fix the problems we're seeing now. I think my good colleague to my left had spoke a little bit about how the two different sides of the aisle see this very differently. I don't think any of us want to lock up children. That's not our idea of a fix. However, we do need support systems in place, which were never put in place when we made these changes. So there's a lot of things that have to change. I think we have some great ideas. I think Representative Fishbein is going to talk to those ideas in greater detail. And I want to thank you for coming tonight, for hosting us all here this evening. And I'm going to pass it on to our good Senator Kissel. Thank you.
Well, good evening, everyone. I've had the tremendous honor of serving Suffield and the towns of Enfield, Somers, Suffield, Windsor, Windsor, Oxy, Scranby, and Granby for the last 29 years. 27 of those I've sat on the Judiciary Committee in the last, I can't even count, probably close to 18 or 20 at least, ranking senator on the Judiciary Committee. A couple of years I was lucky enough to be tied, so one of the tri-chairs. This is a House presentation primarily. The House members are fond of saying there's something wrong with the air in the Senate chamber. Maybe that is true, maybe it's not. But I called up Representative Fishbein, said I'm not going to step on your toes. Senate Republicans have a proposal as well. There's a lot of overlap. The part that's exciting to me is that all of a sudden I'm starting to see in the media these folks that are self-describing themselves as blue dog Democrats, moderates coming out of the woodwork, maybe because it's an election year, or maybe because I'd like to believe that they're listening to the message and the message is not going away. We're not trying to be fear-mongers by any stretch of the imagination. There's a real problem out there. And I think anybody that turns on the news at 11 o'clock, 10 o'clock, 9 o'clock, opens up a newspaper, listens to the radio, these are real problems that are facing Connecticut. We need to address them before there's more victimization. So I'm really honored to be up here listening to Representative Fishbein, who I'm just really lucky to serve as fellow ranking member with on the Judiciary Committee. That guy does a ton of hard work. He came up with ideas in the middle of the summer when we were purportedly working in a bipartisan fashion, but then all of a sudden, the Democrats, at least on that working group, decided they were going to have their own press conference and say, well, the laws are completely appropriate, we don't need to change anything. That's just not the case. I also want to do a shout out, not to get you in the middle of anything, but State's Attorney Cazzandino works in the juvenile justice system. He's a constituent of mine here in Tammy's as well. Here in Suffield, does a remarkable job. Thank you for attending. You really serve the public extraordinarily well. But I'm just so dang honored to be up here with these state reps that work tirelessly for everybody in North Central Connecticut. So I'm on a listening tour. That's my 2 cents, and thank you all very much.
Thank you, and I want to introduce Representative Craig Fishbein. There you are. He's ranking member of the Judiciary Committee from the House side. He's been actively involved in this issue for probably the past couple of years now at least. He's a very well-respected member of the House of Representatives, and he's going to present some background information, a little bit of history about this issue, as well as going through what our potential solutions are in the next session. So I'm going to hand this over to Craig. Thank you.
Thank you, Tammy. So, juvenile justice. On a daily basis, we see it in our newspaper. We see it on TV. We see it on the internet. Very troubling experiences that our state is having to deal with. Some very scary incidents, many of them involving juveniles. Tonight we're going to talk about juvenile justice, and I just want to give you a roadmap before we proceed. Our agenda will contain looking at the data. We hear a lot about we need to look at the data. We're going to look at the data tonight. We're going to talk about juvenile justice reforms that have occurred over the last 10 years or so. Such things as determining when a child is a juvenile for the purposes of adjudication. When can a court order a child be detained? When can a case be transferred from juvenile court to adult court? Other miscellaneous reforms. We're going to talk about what options a police officer has presently when they come in contact with a youth who they believe may have committed a crime. We're going to talk about some proposed new reforms. Talk about what you can do, and then we're here to answer your questions. So, what does the data show? A lot of times you hear in the media people saying, well, in Connecticut, we're safer. We're safer than any other state. The problem is what they're looking at is the violent crime rate. Violent crimes, by classification, are like things such as murder, rape, sex assault. Okay, and if we look at the pink area on the top is the United States average, and you'll see that generally over the last 10 years or so, it's pretty constant, right? And Connecticut, which is the blue, is going down. And that's what they're relying upon, that we're safer in Connecticut. But that is just violent crimes. That doesn't deal with property crimes, okay, which are the other classifications of crimes in Connecticut. And property crimes also include thefts of motor vehicles. And when we think about thefts of motor vehicles, many times there's collateral effect stealing a motor vehicle. You get the senior citizen who can't go to their doctor's appointment. Mom can't bring the kids to school. People say, well, those people have insurance. Their insurance company will take care of it. Well, you tried to buy a car these days during a pandemic to replace that car that got stolen? It's virtually impossible. And insurance companies don't just turn around the next day and make a person whole. So this is the chart that has to do with the rate of property crimes comparing Connecticut to the rest of the country. And I'd like you to focus on this area right here, 2019 through 2020. You'll see how it's a dramatic increase. Where the rest of the country is going down, the pink, Connecticut is going up significantly. So we're going to look at that data a little bit closer. And before we get to unpacking the data, this is the chart of motor vehicle arrests of juveniles compared to adults, the period of time of 2010 to 2019. And this is just arrests. Understand that the clearance rate on motor vehicle theft is very low. And what clearance rate is identifying a incident, somebody calls the police, my car was stolen, identifying a perpetrator, potential perpetrator, arresting that individual, and adjudication in the courts, okay? The average is about 7%, very low, okay, on motor vehicle theft. But look at the trend here. The white line is arrests of adults, 2010 through 2019. Generally, starting in 2017 for adults, going down. But about 2015 for juveniles, going up. So we're going to unpack that data. In 2010, there was 667 arrests for motor vehicle theft. Of those arrests, 149 were of juveniles. 2016, mere 6 years later, 852 arrests for motor vehicle theft, 28% increase from 2010, but 278 of those arrests were of juveniles, almost double in 6 years. As we go on, we look at the subsequent years, you have additional increase, arrests of juveniles. We're going to get to the total incidents in a moment. These are just arrests of juveniles, hard data from the state police as well as the FBI. Going into 2018, we still have an increase in the amount of arrests for motor vehicle theft. We're still about double 2010. 2019, we decreased that doubling a bit to 66%. 2020, 70% increase. Okay, arrests of juveniles for motor vehicle theft. Now, this is the incident rate. And it might be a little bit hard to see this, but in 2011, the actual amount of reported motor vehicle thefts in Connecticut was 6,698 incidents. 2020, 8,451. It's increased in Connecticut. So let's look at that graph once again. Now, red is the USA average, right? And you'll see right here, there's an increase, right? But look at that. This is Connecticut, the blue line. Look at that dramatic increase right there. Connecticut, in that period of time, was 41% increase. The national average, 12. Connecticut is 4 times the national average of increase in motor vehicle theft. You don't see that in the media. They talk about us being safer in Connecticut. And of course, many times motor vehicle thefts involve racing on the highway. We had an incident in New Britain where a jogger was run over by a car that was stolen. You have those other crimes, very troubling, that are tied to that. So that's the data that we're dealing with. So let's talk about some juvenile justice reforms that have been instituted over the last decade. Well, the first thing that was dealt with is determining when a child is a juvenile. You have to determine what's the minimum age. Originally, there was no minimum age. It was police officer discretion. So, a 5-year-old playing with matches, unfortunately burns down the home. Police officer discretion whether or not to arrest for arson, right? That's the way it used to be. But then they took that discretion away. And they said if the child is 7 years or less, cannot arrest child for any crime. That was the law. Just last year, the legislature changed that law, and now anybody 10 years, it's 10 years or younger, cannot be arrested for a crime. The actual request at that time was 12. And I'm going to tell you that that's coming back again this year. I was at a meeting a couple of weeks ago, and that's going to be proposed again, that a 12-year-old cannot be arrested for any crime. But that's presently the minimum age. So then you have to deal with what's the maximum age. Prior to January 1 of 2010, the maximum age was a person under the age of 16 at the time of the commission of any offense. But after January 1 of 2010, it was that and a 16-year-old charged with certain offenses. After July 1 of 2012, it got a little murky. Child under the age of 16 at the time of commission of any offense, and some 17-year-olds, which in the discussions that I've had with law enforcement, many times it becomes confusing. It's difficult based upon a set of facts and what you're going to charge the individual with, whether or not the case is going to go to juvenile court or adult court with some 17-year-olds. And it is possible that based upon a set of facts that a 16 or 17-year-old may be charged as a juvenile and an adult in the same case, presently. So when can a case be transferred from juvenile court to adult court? Before 2012, juveniles aged 14 and older charged with a Class A or B felony and arson murder were automatically transferred to adult court. With juveniles 14 and over charged with the C, D, or E or unclassified felony, there was a discretionary process. The prosecutor could apply to have the case transferred to adult court, and there would be a probable cause hearing. But in 2012, the legislature put a hurdle in there that said that even if probable cause is found, that now the court has to make a finding that it's in the best interests of the child to transfer to the adult court, which is a very high bar to meet. We're going to get to why that's a high bar to meet because it has to do with the penalty aspect, juvenile court versus adult court. And in 2015, the legislature raised the minimum age from 14 to 15. So essentially, a 14-year-old cannot be transferred to adult court for any reason at this time. And the legislature moved the Class B felonies out of the automatic transfer and put that into the discretionary transfer statute, which, once again, because of the high bar, made it very difficult for those discretionary transfers. Here we have a case in New Britain where a 13, 14, and 16-year-old attacked a female delivery worker, and they blinded and maimed her. Because the 13 and 14-year-old were 13 and 14 years old, the case could not be transferred to adult court. So we hear about detentions a lot of times. You stop a young man Saturday night, you think may have stolen a car, have to release them to the parents. Why can't we detain these children? A lot of times we hear that. So we need to look at when can a juvenile be detained, and that's another series of reforms that happened over the last 10 years. Originally, you had to find there's probable cause that the child's committed the crime, that there's no less restrictive alternative available, and one of the following: strong probability the child will run away, strong probability the child will commit other offenses injurious to the child or to the community, probable cause that the child's continued residence in the home poses a risk to the child or the community because of the serious or dangerous nature of the acts the child is alleged to have committed, need to hold the child for another jurisdiction, the child's failed to respond to the court process, or the child has violated the conditions of release. That's where we started with detentions. But then in 2016, the law changed, and certain criteria that allowed detentions went away. So strong probability to run away became irrelevant. That was not a basis to detain the child. Offenses that are injurious to the child came out of there also. And the child had violated the conditions of release before they could be detained, but in 2017 the legislature said no, irrelevant to the detention. That's what it changed to in 2017. Then in 2018, it changed again. Probable cause once again. They added the word appropriate. No appropriate, less restrictive alternative available, which made the test extremely subjective. What is appropriate to you may not be appropriate to me. So insertion of that word became another hurdle. And one of the following: probable cause that the child will pose a risk to public safety if released into the community, cannot be managed in a less restrictive setting. And before I go on, a lot of times you hear, especially with motor vehicle theft, oh, it's just a property crime. The second motor vehicle theft, oh, it's just a property crime. There is no determination that that crime or the succession of those crimes poses a risk to public safety because they are property crimes. Need to hold the child to ensure their appearance before the court or compliance with the court process, or need to hold for another jurisdiction. That is the standard presently with regard to the ability to hold a child, and that's all determined by a court. An officer would apply to the court to have the child detained, but that's the standard that we are left with today. In 2018, there were other miscellaneous changes to our juvenile justice system. A 6-hour provision was put into place. The law says that an officer cannot hold a child for an excess of 6 hours. The Juvenile Justice Program was transferred from DCF to the Judicial Branch and to CSSD. That became effective in July of 2018. And CJTS, which was our place to hold convicted youths, was slated to close in Middletown, Connecticut Juvenile Training Services. That was slated to close June of 2018. However, Governor Malloy actually closed it early, closed it in April, based upon the reduction in convictions of youths. And he touted the fact that we closed that. CJTS, we spent about $59 million creating that facility, and today it remains vacant. And we hear about juvenile prisons. I know when I originally heard about it, you think about a scary place. I had been there. I've represented kids in juvenile court. I've represented victims in juvenile court. I think it's important if you saw what CJTS looks like. So I do have some photographs This is the outside. Looks like a church. Typical residence quarters. Nice open common area. Library. Gymnasium that some schools would be jealous of. There was some educational employment training going on there. So there's a greenhouse and some gardening classrooms, open dining area. And of course, it's a secure facility. It's security inside, security outside. But it remains vacant. As a result of the 2018 changes, committed juveniles were released home or placed in staff-secured, unlocked facilities. Before July 1 of 2018, the maximum confinement for a convicted youth was 18 months with a possible extension of 18 months for a total of 36 months for non-serious juvenile offenses and 4 years for serious juvenile offenses. But after July 1, 2018, the law changed once again, and youths were discharged with or without a warning, put on supervised probation for a maximum of 30 months. That is the maximum penalty that we are left with. In 2019, there were some additional changes. There was the creation of a diversionary program for the first time over motor vehicle theft. Upon the arrest, the youth could apply to go into this program. It would put the case on hold for about 6 months while the youth attended classes and, learned shouldn't be stealing cars, things like that, getting some skills. But that was put into place at that time. Also, there was a determination, I mentioned motor vehicle theft posing a risk to public safety, those kinds of findings for detention. The law said that the juvenile would be determined to pose a risk to public safety if they've been convicted of 2 felonies, been on probation twice, and are now charged with theft of a motor vehicle. So it got rid of that hurdle, although very serious hurdle to get to this point to make that determination. In 2021, we had some other changes. We created a new crime of enticing a minor. A lot of times people talk about, well, it's gang activity. They're making these kids steal cars, that kind of stuff. So we said, well, let's create a law to penalize adults that are potentially having these kids do this. But the problem with this, while we got it passed, we fought over what's an adult. The law says you have to be 23 years or older to be charged with enticing a minor. We couldn't get agreement on 18 or older. So that means if a 22-year-old convinces a 18-year-old to go steal a bunch of cars, for whatever reason, they cannot be charged with enticing a minor. But we did create that new crime. Required the judicial branch to compile data about the number of juvenile detention requests that are made and the number of them that are denied. Raised the minimum age, as I mentioned before, arrest of a child from 7 to 10. There was another bill that actually got voted in the House. It was LCO 9720, which did some other things. Permitted a judge to order a DCF investigation if a child had been convicted of a felony and is then charged with another felony, stealing a car, stealing a gun, or committing a violent crime using a deadly weapon. Currently, a judge does not have that discretion to order a DCF investigation, but this bill would provide for that. Also, if that investigation is going to get done and there's a potential that the youth may be removed from the home, that the family be given information about free legal services that are available in that area in a language they speak. We mentioned risk to public safety a few times. This bill also made an automatic determinant of risk to public safety if the youth is charged with stealing a firearm, arrested for a violent offense involving a deadly weapon or carjacking. So it would make it easier to detain that youth. Ordered home arrest. of a juvenile if they were awaiting trial for stealing a car and they got charged with stealing another car. Eliminated that 6-hour hold that I mentioned before. Ultimately, that bill was defeated, 88 to 57. All of the Republicans voted in favor. There was only 4 Democrats that supported that initiative. So that's basically what happened in 2021 by the legislature. Now, there was another thing that happened a few months ago, September 1. The judicial branch announced that they were creating a process to permit an officer to get a juvenile's record. And what happened there is when an officer arrests a youth, let's say once again on a Saturday night for potentially stealing a car, and they want to apply for a detention order, before September 1, all the officer had available to them was that particular incident. They could not, because juvenile records are sealed, find out that, let's say, the youth had been arrested the night before in an adjoining town for stealing a car, or was awaiting trial for stealing 6 cars. They didn't have access to those records. It's one of the things that we pushed for over the summer, and the juvenile branch, the judicial branch was able to put in place a probation officer 24/7 so that an officer could inquire about that record, also a bail commissioner, because as I mentioned before, sometimes these 16 and 17-year-olds are being tried in adult court and juvenile court. Well, the juvenile court probation officer doesn't have access to the adult records. They would have to go to the bail commissioner. So that gives that access. And my understanding is that since that time, that has been used over a dozen times by various departments across our state, and I think it is a good step forward. So that's 2021 where we ended up. So presently, what options do the police have when they encounter a youth they believe may have committed a crime? Well, they could warn the child and take no further action. They could refer the child to a juvenile review board or other agency for services. Every town has some sort of system within their town, which is a non-court system to deal with these cases, and the officer has the ability to refer the youth to that process. They could charge the child with the crime, release the child to their own custody, charge the child with the crime, release them to their adults or guardian, and refer to court, arrest the child and obtain a court order to detain the child, and bring the child to the juvenile detention center. And we presently have 2 in this state, Bridgeport and Hartford. And I think that's also important if you see a little bit about what they look like. We do have some photographs. This is the courtyard in Hartford. There is security there. And this is just the detention facility, though. A typical room. Bridgeport, we have just a few photographs of. So presently, I'd like to present you with a hypothetical case of where we stand with juvenile justice in Connecticut. Let's say a 12-year-old is arrested for assault 3 and breach of peace for punching another 12-year-old in the face without provocation at school. The 12-year-old makes comments that he knows there will be no repercussions. Shortly thereafter, the 12-year-old is arrested for assault 3 and disorderly, for assaulting a child on the school bus. The video shows him punching the victim in the face and getting on top of him, continuing to strike him. After turning 13, the young man is observed by a teacher making a rule violation. When called out by the teacher, the young man says, "If you say anything, I'll shoot you." No arrest is made. 13-year-old is then arrested for disorderly conduct for interfering with police officers when called for a fight at his residence. He takes a swing at one of the officers. Shortly thereafter, the 13-year-old is arrested for assault 3, threatening, criminal mischief, and other things was a domestic at his mother's residence. He hits his mom in the face, spits on her, slaps her, pulls her hair. Assault's broken up by her older brother. Young man grabs a knife and threatens everyone in the home. After turning 14, the youth is arrested for a bunch of other things. Officers are responding to a report that he's throwing knives at family members. The incident began when the grandmother questioned him about a bullet hole in his bedroom wall. He's remanded to juvenile detention. His probation officer was notified. Shortly thereafter, the 14-year-old is a suspect in an investigation of a non-fatal shooting. And a few weeks later, as a result of a separate incident, the 14-year-old is arrested for murdering a 32-year-old male. Those are your facts. That's your hypothetical case. So let's dispose of those facts. Well, because the accused is under 18, they go to juvenile court. Because he's under 15, the case cannot be transferred. None of those cases can be transferred to adult court. If convicted of murder, as well as the other crimes that are pending, maximum penalty is a total of 30 months supervised probation with or without residential placement. At the age of 22, 4 years after reaching the age of 18, he applies to the juvenile court, and those convictions are erased off of his record. And that is not a discretionary erasure, it's a mandatory erasure based upon request. I don't know how we explain that, especially the murder, to the grieving family. More importantly, I'm going to tell you that's not a hypothetical case. That case is going on today in Connecticut. And in that case, the young man had identified having problems. So they took him out of the regular school, and he was in a diversionary school where there's only 3 other students in his classroom. The police had identified him as having an affinity for basketball. They hired a professional trainer to work with him, to get him engaged. Problem was, he just wasn't making the appointments to work with the trainer. And this is where we ended up. So that's what we presently have for a system in Connecticut. So the question is, how do we deal with this? What reforms can we possibly present that could perhaps address some of these concerns? So I bring to you tonight some proposed reforms. Well, first of all, that 6-hour time limit should be flexed from our perspective. If an officer applies for a detention order and they're waiting to hear back from a judge, the 6 hours should not be as draconian that you have to release the young man. Of course, if the officer doesn't apply for that, 6 hours would remain in place and the youth would have to be released. On the detention orders, before the Judiciary Committee, we had a few juvenile judges come before us this year for reappointment, and I wanted to know, have you ever denied any of these and why? We couldn't get any answers. So we would have a law that says if a detention order is sought and it's denied by the court, that within 24 hours of that denial, that the judge articulate in writing why they denied it. I think the public should know, or at least the people that review reappointments of judges should know what's going on behind the scenes. In 1983, Connecticut said, we're going to take domestic violence serious in our state. When somebody's arrested for a domestic violence incident, we're going to have a next day arraignment. We're not going to wait. Presently, our system says that when a youth is arrested, they have to be arraigned no more than 2 weeks after the incident. A lot of bad things can happen in 2 weeks. So carve out certain things. And if a youth is arrested for a Class A misdemeanor, a felony, a charge resulting in loss of life or serious physical injury, a sex assault, or an offense involving a firearm, next day arraignment. That's important. And when you have that arraignment, you're going to get family services involved. What programs are available for this youth so that maybe they don't end up with a conviction. You know, we met with DCF a few months ago to talk about various changes in our proposals. And I learned in that meeting that apparently Connecticut has more diversionary programs than any other state in this country. They can't identify all the programs, but if we have all of these programs, then let's utilize them. Let's get these kids some help, and maybe we can save some kids from the system. So at the arraignment, we're going to have some sort of evaluation as to what programs are available. You know, presently, theft of a motor vehicle, most people don't realize that if you own a Lamborghini and it's stolen, and you own a Volkswagen and it's stolen, they're both motor vehicles, but they're charged differently. There's different levels of larceny based upon the value of what is stolen. But I have to tell you that I think the person who owns the Volkswagen probably has more collateral consequences, with all due respect to those who own Lamborghinis, right? You know, so we would have theft of a motor vehicle come out of the larceny statutes and treat it, motor vehicle is a motor vehicle. And if it's a second occasion, it's going to be an automatic transfer to adult court. It's the only way that you can possibly stop the repeat offenses here. We would have GPS monitoring for these youths that are awaiting trial and get arrested for stealing another car. When we talk about those diversionary programs, and I mentioned that apparently there's a lot of them. We don't know what the efficacy rate of them is, what the recidivism rate for those that go through them is. You know, I think it's about time that we had a report. What diversionary programs do we have? What do they do? And are they good? So I think the legislatures, it's appropriate to demand that report. You know, presently, when let's say a youth from Hartford goes to Rockville and steals a car, many times that case is adjudicated in Hartford, where the youth resides, not in Rockville, where the incident happens. We don't treat adult crimes like that. Now, who does that favor? That favors the alleged perpetrator, and it negatively impacts the victim. The victim wants to go and speak to the prosecutor or something like that face to face. They have to travel from Rockville to Hartford. Well, we should be adjudicating these cases where the event occurs, not where the youth lives. That would be another change. And we have to look at CJTS and utilizing that for something. As I mentioned before, $59 million of your tax dollars was spent opening it. It's been vacant and not used for years now. You saw the pictures. It looks pretty beautiful. If anything, for employment skills, you know, there's so many things that we could do with that. So let's look at that. Have the judicial branch and DCF look at what could we use that facility for. I'm not going to mandate anything, but I'd like to look at options. So those are just some of our proposed reforms. And I guess we basically conclude with, what can you do? Well, we've been asking for a special session for months now. You know, the legislature can only pass laws when it is in session. We're not in session all year round. Our next session starts the beginning of February. Since July, we've been saying, this is an emergency. Please call us into special session. There's a couple of ways special session happens. The governor can call us into special session. The governor did that with marijuana. We had a special session to legalize marijuana over the summer. The governor did that with regard to the police accountability bill last summer, well, the summer before. That's one way. Another way is that the legislators, 2/3 of the House and Senate, can sign petitions to bring us into special session. The other side of the aisle has not been supportive of that overture, so we've been unable to get those signatures. So here's some telephone numbers. You know, if you believe that we should be doing some changes, you know, I want to at least have the debate. You know, you have our proposal, what's wrong with it? Put it up on the board, let's vote. But being silent is not the answer. I know that next February we will be dealing with a lot of these things. We've had a very bad summer with escalation of crime. I would hope that something will happen before next session, but that's what you could do. And with that, I'm going to turn this over back to Tammy for any questions that you may have. There's a microphone up front. Thank you.
Thank you very much, Craig. Really appreciate the exhaustive overview of the statistics and everything. I think it's very meaningful. I want to find out if anybody in the audience has any questions. What you can do is raise your hand. We'd like to know your name. And I think there's one question right down here already, and there's a microphone right over here. Yeah. That'll be easier if you can get you off the stand.
I'm sorry, David Seymour. I'm from Manchester, Connecticut, so this is meaningful to me, as Mark Anderson said. Let me ask you a few-part question. Who's ultimately responsible for the child, and is it a situation where it's reliant on social services, i.e. DCF, or get them back in school, and there's no ultimate responsibility in the other avenues that have been unexamined?
Get Craig back up here.
Yeah, no problem. I mean, ultimately, a parent is responsible for their child. However, it begs the question, should a parent be held vicariously liable for the bad acts of their child? I do not propose that that should be the process in Connecticut. I will tell you that I've had quite a few moms contact me that are frustrated because their kids are out of control. So to hold a parent responsible because a kid does something bad, I think I don't know of any state that does that. I'll tell you, you may have seen the 14-year-old young man from Hamden a few weeks ago who was shot in the head and dropped off in Waterbury at St. Mary's Hospital. He, I first heard about that case. I thought, well, he got in a car with some people and, just bad kid, or with some bad people. But then we come to find out that young man had been arrested for stealing a few cars. He was on probation, and he actually had electronic monitoring. We don't have GPS monitoring. We have monitoring so that the parents know whether or not the youth leaves the home. And on September 29th, he was in court, and what was before the judge was taking him off electronic monitoring. And you know who objected? The mom. She said, don't do that. 3 weeks later, her son's dead. How do you hold the mom responsible, with that kind of stuff?
The law doesn't seem to be holding the child responsible at the end if it just goes away mandatorily. Does that, or the mandate? Do you know what I mean?
The erasure?
It's erased, and then they walk into society at any age after that age, and now are they reclassified? Are they not classified? Did they do it? Did they not do it? How does that?
It's erased. It's like it never happened. So, philosophically, there are certain crimes that I believe, I represented a young man who got arrested for sex assault in the 4th. He was 14 at the time. He had some issues and it was in his home, right? So he pled guilty to a lower charge. I got him some help, and I felt comfortable getting that erased off of his record because I knew the path that he was on, But murder? I just can't. With no test, you know, anybody who has any conviction has the ability to apply to the Board of Pardons and Paroles to have that erased off their record, right? And I've represented people before that board, and that's tough with those higher crimes, right? You've got to show that you're doing stuff in your community, that, you know, you haven't been arrested for other stuff, and you know, so I would have no problem having some sort of a middle line threshold. You know, everything above, you got to go to Board of Pardons and Paroles, and everything below can get erased, right? Setting a standard. You know, that's my way of looking at it. But, you know, I agree with the concern. The automatic erasure, I think, is a problem.
Right, and the structural responsibility, it seems as though it's the Democrat agenda, right? And is it DCF or is it restorative justice that they're after? But then does that stuff ever get solved? Structurally.
I will tell you my experience over the last 10 years, DCF has changed dramatically. In my experience, I mean, when you say Democratic agenda, I really haven't wrapped my arms around that. I can tell you that in my experience, you saw the bill I put up on the board, right? Those 5 things in that bill seemed to make a lot of sense, but only 4 Democrats supported it. I'll tell you that, you know, John Poriello is in the audience here tonight. You know, we had a special session a few months ago up in Hartford, and he approached some of the Democrats and said, okay, you've seen the Republicans' plan. What do you think about it? Would you support it? And their response was, well, what does my leadership think of it? So, you know, that's what you see in Hartford, a lot of the reasons why stuff doesn't get passed or reforms don't happen is guided by not your elected officials. That's the best I can say.
But thank you for that question. We have another one right over here.
Good evening. My name is Quentin Rohr. I'm from East Granby. I'm looking at back in the 80s we had gangs involvement with violent crime, and they were told that, you know, that youth would be employed and not have the same penalties as an adult. And then at the time, I don't have all the numbers in front of me, but they were applied with adult convictions. So it tapered down. People shied away from doing that, pressure from police and whatnot. So if you look at statistics, 60s, 70s, 80s, just because your crime's coming down doesn't mean you water down the punishment. You can have one murder, and then the kids, we have in Manchester, a murder of a teenager with a rape, and he's going to maybe serve 2 or 3 years and then have his record erased. I mean, that's a pretty serious crime. I mean, it doesn't get any more serious for me. So we've watered everything down, so it's going to take a lot to restore the system and put rules in place. So then, Juvenile Detention Center, I think 2015, there was a chokehold incident, and I think that's what turned Malloy off from the facility and said, hey, this is pretty rough, and it started its idea to close it, at least in my mind. So you say, you know, alternative program. I'm like saying, okay, put them in the detention center and say, here's an alternative program. You can step out and work on this program. If you don't follow the program, back into the center you go. You can't eliminate crime by not punishing anybody. So the crime rate could start going down, but you're still watering down the punishment. So even if it's one incident, it's not right to water it down to the level we're at.
Part of the mindset here is that prison, jail is at a level of harshness that putting a youth there hardens them. But the overtures by the legislature are so far opening. For instance, you know, I mentioned raising the age to 12, which will come back this year. Another thing that will come back this year is the banning of chemical agents. with juveniles. So even in the detention facilities, they want to ban chemical agents. So, you know, at a level, when a fight breaks out in the cafeteria, what does a corrections officer do if they can't use a chemical agent? You know, we did face that this year. I got them to agree that they would look at alternatives and come back to us. But a lot of the things that you see coming out of the legislature are more for loosening up penalties, especially with regards to juveniles, because the feeling is that we're not going to use our correction system to parent these children. So, but you have to find the happy medium. There has to be, and it's certainly not where we are today. Utilization of 14-year-olds happens for these crimes because they know that those youths are of a certain, you know, physical ability, intelligence, but they can't be tried as adults no matter what they do. So they're used as pawns. So,
And I think we also need to get back to balance, because the pendulum is swung way too far one way as far as benefiting the criminals. I think we need to get back to considering the victims a little bit more than we have lately too. And you know, what you're bringing up is one of the reasons that we're having this tonight, because we need public input. We also need public help in trying to get some of these proposals over the finish line, because we're having a problem getting the attention of some of the leadership in Hartford. So that's why we're giving you some phone numbers. Do call and tell them you want to see reforms like this. So another question, do you have somebody else in the meantime? Or?
I just have a comment. I'll give you my 2 cents. I do have some master's work in sociology from Southern, so it's all state connected. So I'm just wondering myself if they're giving, the Democrats are giving chips to the urban centers, and I'm not trying to be inequitable, but they're almost giving handouts to the gangs. Does that make sense? Because now these kids are part of these, possibly statistically, these crime rings, and they're getting away with it, and then they hear about it, and then their friend does it because their friend did it, and they heard that they didn't get arrested. So it's a lot to do with parenting and lack of parenting, youth services, but it's also like when Roland gave out credits to the retirees to get them out, you know, they get a little bit more. So you're right about that pendulum swing. It's not quite balanced out. But I think that if you eliminate the penalties, just input, opinion, a Rolls Royce and a Volkswagen should be equal, not inequitable for some of these kids, you know, because if they get charged with these larcenies and they have to restore that at the end of the day, monetarily, that's going to be a challenge for children who are already at disadvantage. So it should be a Ford equals a Benz, and a Benz equals a Dodge or a Clunker, and so forth. Just what Craig had mentioned in that. I just wanted to bring that point to present. That's all. About restoring equity, like you're saying.
Okay, thank you. And also that with the anecdote I told you about the woman who had her car stolen while she was waiting for it to warm up. This was a beat-up old car that could not be replaced easily. Really not a theft target either. And it hurt that woman more than it would if they stole, you know, somebody else's Lamborghini. They could afford it. Any other additional questions? I have them right down here in front.
Hi, good evening. Brian Casentino from Suffield. First, I'd just like to applaud Representative Fishbein for an outstanding presentation. The police departments, absolutely. And State's Attorney's Office might want to enlist you to give a presentation to new employees, because that was extremely thorough. And I thought it was very important that you showed the illustrations of Connecticut Juvenile Training School in Middletown, of course, and the detention facilities, because as I'm sure representatives and Senator Kissel know, all of the individuals who were previously at the training school are now being treated post-dispositionally at the detention facilities. And My question would be, do you think that those facilities are far smaller, I'm sure, Representative Fishbein, you can probably get into detail about the acreage of the training school compared to the detention facilities. Obviously, it's very clear, they're much smaller, they can't play sports there, they don't really get outside much. Is the new treatment facility option, is it close to being adequate what could have been offered at the training school, which was really built for more involved and really wraparound level of treatment for the high-risk juveniles?
Yeah, the detention centers are nowhere near adequate to do for convicted youths, especially what CJTS was set up for. Nowhere near the space, the adequacy, the staffing, the programs. So, you know, I don't want to be a pessimist about youth that are in residential hold there for the 30 months, but I can tell you I had experience with youths at CJTS that are now productive members of society. I do not see it happening out of the detention facilities that are presently being used. So, but thank you, and thank you for your kind words.
Thank you.
I did mention John Poriello before. John is the executive director of, and John's going to ask a question, I guess, of Connecticut Safe Streets, a very important group here that's, John's been following us around about these issues. You know, if you want to go on Facebook or whatever, it's a good group to follow with regard to these issues.
So, thank you, Craig. Craig, one of the things that's come up at prior meetings that I didn't hear tonight is there's an estimate going around in law enforcement of the number of repeat offenders that appear to be committing the vast majority of crimes. Can you share that number with this group?
Yeah, it's estimated that there's approximately 115 youths that are involved in theft of motor vehicles. I can tell you in particular there was 84 motor vehicle thefts in Waterbury last year, and that was attributed to 12 youths. So the question is, since you got this small group committing all of these offenses, how come they keep on committing these offenses? And a lot of it is the ability not to detain, the diversionary programs and things like that. But that's what was being reported to us. I will tell you that I had a youth in my office a few weeks ago who had been arrested for stealing a car, and it was his first time. And I asked him, why'd you do it? And he says, because he sees it in the news. And, those kids, his peers that are doing this are sort of like looked up at as the risk taker. It's fashionable. We shouldn't be there. So I'm just as concerned about the repeat offenders as I am by the one-offs that, because there was a case, it was Madison and Hartford. I can't remember where the kids were from. They stole a Porsche or something like that. 2 kids died. And you got kids dying over stealing cars for joyrides. It's not a very good thing.
So Craig had brought up the attitude of Democrats, with the exception of a very small number of Democrats that are in support of the really creating accountability for criminals. And I was astounded at the level of denial that elected officials have in this state. So if you take nothing away from this meeting, please call the governor's office. The governor is in denial of what we see every day as far as crime. And he certainly doesn't want to take any action. But the only way that's going to happen is if he gets pressure from each of you. So I would encourage you to call the governor's office repeatedly, like make it part of your day. Put it on your calendar, day after day. And encourage your friends, neighbors, co-workers to come to meetings like this. We have another one on Thursday in South Windsor at the Recreation Center. So I would encourage you to come to that. And also join our Facebook group, which is Safe Streets CT, or go to safestreetsct.com. And really, we have to support the leaders that are a stand for public safety. So thank you, Craig, and thank each and every one of you up there. I quite frankly couldn't do your job. So thank you.
Thank you, John.
And John, thank you and your group for doing what you do. You've done a really good job keeping this in the public spotlight. Carol Hall, Representative Hall, has a comment you'd like to make as well.
I just want to circle back to some of the items I touched on from the beginning. If you go back and you look over the many years of changes to our justice system that the legislators have enacted, it's like anything else. If you dumb your laws down so low that there are zero consequences for your actions and there's no punishment of any sort that follows these crimes, of course, you're going to have more and more crimes. It's common sense. It's like when you raise your own children and there's no punishment for bad behavior, you don't expect them to improve. And the punishment doesn't have to be incarceration. We've eliminated all punishment for our youth. And if you look back over the many years of when grassroots effort has made a significant change, the easiest thing to point to is drunk driving. So Mothers Against Drunk Driving has changed our drunk driving laws across this country and basically made grassroots changes with their pursuit of changes through legislation. So the only way we're going to make significant changes is if folks like you here tonight reach out and ask for these changes, or we're just going to keep doing the same thing over and over again, and there'll be no consequences for these youths. The detention centers, I can speak from law enforcement perspective. I sit on our public safety committee and have listened to years and years of frustration from our law enforcement families saying, we can't get these kids into detention centers. The judges won't listen to us. The 3 strikes and you're out with the use for the robbing of cars and the theft. It's not just, like Craig mentioned, it's not just a property crime. These kids are racing down the highways if it's their 3rd offense, knowing that that 3rd offense is going to get them jammed up. They're putting you at risk, they're putting your families at risk. It isn't just a property crime. So until we change our laws and people come out and really ask for the changes, we're not going to see any changes. So I implore you, please definitely reach out to legislators, call the governor's office like you've heard here tonight. We appreciate anything you can do to help us push some agenda items that we touched on here tonight. But we definitely need some significant changes. And one thing that I learned through doing a lot of this research over time is pursuits aren't a felony for these children. So when they steal this car and they're driving down 91 at 120 miles an hour, it's not a felony. So pursuits by a police officer, when the police officer is pursuing this youth, we have to make these decisions that these youths are making. There has to be some consequences. And I don't think any of us up here are advocating for jail time for these youths, but there has to be consequences. So that's...
I just want to add to that too. And if there's no consequences, you aren't helping the youth either.
No, absolutely.
It's yeah. Anyway, additional questions? right down in front.
Hi there, Don Miner from here in Suffield. I think one of the things that concerns me is you have not only the repeat offenders and multiple repeat offenders, and you have the tendency for them to now flee because the police aren't allowed to pursue for property crimes. But you have a lot of these kids carrying a gun. And I think that we ought to differentiate. You know, if they're carrying a gun, maybe they get treated as an adult. I mean, you had the lady in Glastonbury that came out and they actually shot at her. I assume, I don't know if that was juveniles or not. I think they finally caught those kids. But, you know, if they're carrying a gun and they go to shoot at a police officer, what are you doing? I mean, that's ridiculous. One of the stolen cars from Suffield, before they had the no pursuit policy, the police officer pursued them down 91, broke it off when the car hit 100 miles an hour and turned off its headlights. 2 days later, that car got pulled over. A 16-year-old was driving the car with a stolen handgun. And it was not his first rodeo. So I think that one of the things we need to really pay attention to is if they've got a weapon, that ought to change the whole set of consequences.
Yeah, I can tell you from experience this last session, that was an area that I was focusing on. And the pushback I got was, you know, one of the things was stealing a gun. Well, what if they didn't know the gun was in the car? You know, that kind of stuff. Or what if they stole what if they took the jacket and there was a gun in the pocket? I don't care. They stole a gun. Especially when they're flashing it or something like that. You know, possession of a handgun by a youth under the age of 21 is a felony. You can't get one legally. You know, so those crimes under our proposal, they'd be charged with a felony for possession of a firearm, possession of a handgun without proper licensure. Felony should be an automatic transfer to the adult court. That would address that. That's part of our proposal.
And Carol had a comment that a car is being used as weapon as well during some of these car chases that you see going down the road in pairs. Anybody else have any additional questions?
Hi, my name is Jim Mclaughlin. I live in Windsor. I grew up in a home where there were rules and there were consequences. I think we should get back to that as our elected officials, hoping that you would work towards bringing back consequences to those that break the rules. Pretty simple. I have two questions. One is, to what degree do you give victims any input into the legislative process that goes forward so that victims can have a say in how things play out? I'm familiar with the balance of government between the executive branch and involving crimes. I can see that as the police officers enforcing the laws created by the legislature. So my second question is, where's the judicial branch on all of this? The first question is, what input do we give victims into the legislative process? The second question is, where's the judicial branch on this?
Mike's going to take the first one.
Sure.
It's still up. Okay, the light's off. There we go.
Sir, in reference to your first question, legislative process, if there is a proposed bill, there will be a public hearing, and that is open to everyone. So you'll have hopefully at least 5 days notice, and you'll be able to, individuals will testify for at least 3 minutes, and legislators on the committee can ask you more questions. So there will be public input, and I would strongly encourage you to, you know, speak out, and it will be heard on the public record.
As a practitioner and as a victim of crime, over the last 10 years, I think our system, not only through the legislature, but through the court system, because there is no victim until there's a crime, right? And many times you have notice of that. The judicial branch has set up the Vine system, where you can register when that particular perpetrator, not for the juvenile court, because those cases are still sealed, but for adult court, can get notice when that case is going to be there. And that's a much better system than we had 10 years ago, when we had no idea really when the case was going to happen. As far as a member of the legislature, I think of any group that I could possibly be up here with tonight, this group has been very supportive of victim rights and having victims be able to have their say. Some of the bills the bill that you saw up there, we did this past year, a lot of that had a public hearing. It was Bill 6669, where we did have victims come and testify to our committee. If we were to have a special session, though, on the proposals that you've seen tonight, usually in a special session, there is no public hearing if it's an emergency certification. So when you saw with marijuana, there was no public hearing on that particular bill. With police accountability, there was no public hearing on that particular bill. So it really determines, which track that particular bill has. But anything that's coming before the legislature, anybody can reach out to their representatives or to all representatives and speak their mind as a victim or just an interested party. As to the judicial branch, I don't want to speak for the judicial branch. I think they have been open, but a lot of those individuals are appointees. I will tell you that I do give them credit for the one thing that I did point out that they instituted September 1, giving police officers access to records. They didn't have to do that. They did that administratively. I will tell you that, and it hasn't been, this is the first you're going to hear this tonight, I was contacted last week by the chief administrative judge who indicated that they are going to be putting in place a series of expedited arraignments, which I did address tonight. I don't know where their line is. I don't know which particular crimes they're going to call out for those expedited arraignments at this point. But the fact that they're doing that stuff on their own without the legislature saying you have to do that does give me a sense of faith that they are with us. So that's the best that I can answer that question.
How about one more question? We're getting up on a little past 7:30 now, so one more. And do you have?
Hi, I'm Steve Mosher. I live in East Granby. Just wondering why we don't employ technology for this. Why aren't we doing GPS tracking? You made a comment about how there's actually very few youths that are doing these repeat crimes, and it seems manageable to try to do some house arrest with GPS tracking to sort of mitigate this. Is there any leeway to do that?
Yeah, so presently we don't have the technological infrastructure to have GPS. GPS would entail someone leaving the home. Did they go to Stop and Shop or Kohl's or wherever, right? It's 24/7 monitoring. We do not have the ability to do that. We do have the ability electronically to have a form of house arrest. So you can tell somebody they can't leave the home, and an alarm goes off. There's a monitoring system essentially if they do leave the home. As far as the GPS issue, though, Bill 6669, which we had this last legislative session, did have a GPS provision in it. So get the infrastructure, have it put in place. That bill we did get out of the Judiciary Committee. It was a squeaker. It was 21-17 that bill got out. But because there's an appropriation, there was an expenditure that was tied to the GPS, it has to go to the Appropriations Committee before it gets voted on by House or Senate. And when it got to the Appropriations Committee, the fiscal note on the GPS portion was approximately $1 million. For, well, I'll say it, political reasons, the bill didn't get voted on in the Appropriations Committee. It died. The argument was, we don't want to spend $1 million on GPS. My response was, all the money that you spend up here in Hartford, I think $1 million is worth the safety of our individuals. So, politics killed GPS this last legislative session, but that's why you see in that bill that I put up on the board, it didn't have the GPS that we voted on. We said, okay, you don't want to spend $1 million, we'll just have house arrest. You have the infrastructure. But you see, that didn't pass either. So, you know, the Republicans are in a minority in Hartford. I mean, that's the truth about GPS at this point. But I will agree, and I will tell you that gang members in particular do not like it when their mule that they're sending out to buy, you know, to steal a car has got an ankle bracelet, right? So I think it would be a deterrent, ultimately.
And I serve on the Appropriations Committee. We were waiting for that bill to come down that day, and it was stopped by the two chairs, the two co-chairs of that committee. It prevented from getting a vote. It was on the agenda. They stopped it beforehand. So. And what John Straits mentioned, you know, it is vital for the public to get involved. So if you agree with some of the ideas that we have here tonight, by all means, call the governor, call any of the legislative offices. If you're represented by somebody other than us, by all, well, you can call us too. But pick up the phone, call your representatives, your senators. The more noise that the public makes, the better off we're going to be. So again, thanks very much for being here tonight, and I hope that you got something out of it. And I want to thank Craig especially for such great information. So have a good evening.